The criminal law and procedure question from July of 1994 is another challenging problem. It is not challenging, really, to spot the issues. The call of the question lays them out for us fairly well. What is difficult about this fact pattern is the difficulty common to just about all of the short fact patterns. The need to find a home for every last detail, and the need to interpret one or two of those details in multiple ways. Take a look at the four-part call of the question. 1. What factual and legal defenses are available to Doug? And, if they are accepted by the jury, of what crime, if any, should Doug be convicted? Discuss. Well, we don't even know what crime Doug is being charged with yet, but we do know that we can focus on various defenses. 2. If Doug is convicted, how should the appellate court rule on the argument that the prosecutor's actions during jury selection denied Doug rights under the 6th and/or 14th Amendments to the U.S. Constitution? Discuss. Well, this looks like a short answer question with two subparts, based on the 6th and 14th Amendments. 3. If Doug is convicted of first-degree murder as charged, and the jury is instructed that it has no discretion as to penalty, would imposition of the death penalty violate Doug's rights under the 8th Amendment to the U.S. Constitution? Discuss. Well, the answer to question 3 is yes. That's the answer, but we're going to have to explain it in a little bit more depth below. Then, finally, question 4. Did Jane act lawfully when she shot Al? Discuss. So, we've got to deal with two killers in this fact pattern, not just one. Well, we also know now how to face our first call of the question. What factual and legal defenses are available to Doug in his defense against first-degree murder charges? And as we run through those defenses in our mind, we know that we can examine the facts and suggest no premeditation to reduce it to common law murder, perhaps no intent to kill, reducing it further to manslaughter, or perhaps self-defense, defense of others, which might turn it into no crime. We'll have to examine the facts to find out. Well, we only get 3 short paragraphs of facts, so it shouldn't take us too long to get an idea about what's really going on here. Let's have a look together. In paragraph 1, we meet Jane. She's killed somebody, as we know from the 4th call of the question. Jane is a police officer out of uniform. She attempts to make a lawful arrest of Al for distribution of a controlled substance. Well, stop right there. If this is all that Al is charged with, distribution of drugs, Jane is going to have to have a very good justification for shooting him. Let's read on. Doug, who did not know either Al or Jane, arrived on the scene, a poorly lit alley, and did not realize that Jane was a police officer, because Jane was wearing civilian clothes and holding a gun on Al. Doug thought Jane was robbing Al. Well, so far so good. That looks like a reasonable situation as far as Doug is concerned. And so far, he hasn't done anything. Let's see what happens next. Paragraph 2. Doug ran up and shoved Jane away from Al, who fled down the alley. Jane fired a shot at Al, killing Al. Okay, stop right there. We've got a fleeing felon, but a felon who has not committed a violent crime and who Jane could not reasonably foresee to be a violent felon. Her shooting of Al for fleeing a drug charge is almost certainly unlawful. But now, look at what Doug does. Doug then wrestled the gun away from Jane and shot Jane, killing Jane. Well, once he disarmed her, he didn't have any need to shoot her. So certainly it looks as if Doug has done something wrong at the time that he shoots this police officer. Paragraph 3. Doug was indicted for murder of Jane under a statute which mandates imposition of the death penalty for first-degree murder of a peace officer who is in performance of her duties. During jury selection, over Doug's repeated objections, the prosecutor used his peremptory challenges to remove all African Americans and death penalty opponents from the jury. Well, we're going to have to consider each of these separately. It seems as if removing African Americans with peremptory challenges is likely to be a much bigger problem for the prosecution than kicking off people that have political opinions hostile to the death penalty. Well, that's it for the facts. We get the 4-part call of the question again. As I indicated up front, This is a straightforward question, and it's also a comparatively simple question. It is not necessarily an easy question, if for no other question than that we've got to finish on time. Plus, anytime we've got a short fact pattern, we've got to be especially sharp with factual analysis, because there aren't a lot of details for us to get bogged down in. So take a look at my outline of issues. You'll see that Doug's defenses to homicide cover a fair amount of the checklist that we were able to rehearse before we even looked at the fact pattern. Defense of others appears to be the primary defense. Self-defense is another possible defense, and then we look at Doug's criminal liability. First, we consider the charged offense, first-degree murder of a peace officer in the performance of her duties. Then we look at homicide liability for common law murder and manslaughter. It's a very simple organization, but we're going to have to do some fairly intense analysis to cover the ground sensibly. And we're going to have to do it in a concise way to finish on time. Next, we consider the criminal procedure issues arising out of the prosecution's conduct. First, we look at the peremptory challenges used to kick off all the African Americans. Clearly, that's a violation of the 14th Amendment. With regard to peremptory challenges for death penalty opponents, that is much more likely to be fair game, particularly in the guilt or innocence phase. Next, our answer to question 3 almost is as short as the one-word answer I proposed upon first reading the call of the question. And then, with regard to Jane's shooting of Al, there isn't a lot of internal organization. It's another simple, straight question, and we can provide a simple and straight answer to that question along with some factual analysis. So here, it's pretty clear that the heart of this question, the most difficult part of this question, is the first call of the question. This fact pattern can be characterized as a setup for question 1, and then everything else is sort of an afterthought. So all of our real work is going into the first section. So let's have a look at my answer, and I'll show you a number of details that probably you've already noticed, but I want to draw them to your attention anyway. Look up front at what I do in the very first 2 sentences. I lead with the facts. I set the stage for the analysis that follows. Obviously, this is not a fact pattern that is asking us to dissect homicide. Instead, it's asking us to go deeply into the defenses to homicide, and that's what we do. First, we start off with defense of others, and we focus on the 2 different violent acts that Doug is responsible for. First, he shoved the police officer, and as you'll see from my analysis in the first paragraph, that's almost certainly going to be not a crime, because it looked reasonable to Doug as if Jane was robbing Al, and so his use of non-lethal force appears to be reasonable as a defense of others. Then Doug takes the gun away from Jane and shoots her to death. And he did this right after seeing Jane shoot Al. So he's used a deadly weapon, and that establishes malice. The viability of his defense of others defense depends on a wrinkle in the law, which is commonly tested on the multi-state. Some jurisdictions allow someone to use a reasonable mistake as a defense when someone uses deadly force to defend others. And another set of jurisdictions don't allow that defense. Here, although it is apparent that Jane did not have the legal authority to shoot Al probably didn't have the right to defend himself with deadly force under the facts anyway. But more importantly, I think that the common sense approach here is to recognize that after Doug had disarmed Jane, she no longer posed a threat to anybody, and he didn't need to shoot her. So we focus on the self-defense issue, and that's where I bring out that line of reasoning. Jane couldn't make a deadly attack on Doug because he had the weapon. So now we focus on the criminal liability of Doug. We look first to the charged offense, first-degree murder of a peace officer in the performance of her duties. Probably he will escape criminal liability for this charge because he did not deliberately murder a police officer whom he knew to be participating in law enforcement activities. It looks more likely that this was more of a spontaneous event that was not subject to premeditation, so I don't think first-degree murder is a likely result of a fair trial in this case. Yet, next we focus on homicide liability for common law murder and manslaughter, and here, again, it seems evident to me that Doug didn't have any right to shoot Jane. He disarmed her. She no longer posed a threat to anybody. Perhaps he acted out of great passion, where he believed his life was in danger. Maybe there could be a voluntary manslaughter verdict, but it seems more likely that Doug is guilty of common law second-degree murder. So, now we focus on the prosecution's conduct, and here, all we're really doing is lining up the facts, analyzing them in light of the law, and reaching a conclusion. The Equal Protection Clause of the 14th Amendment guarantees the right guarantees that a criminal defendant will be charged by a jury pool that reasonably reflects the racial composition of the community. At least they are entitled to be tried by a jury that hasn't been tainted by discrimination on its face. So, Doug gets a new trial because the peremptory challenges were used in a racially discriminatory fashion. But with regard to death penalty opponents, there is not really a Sixth Amendment problem. A fair and impartial jury is not compromised by peremptory challenges being used to weed out people with certain political opinions, like, for example, hostility to the death penalty. Next, we focus on the third call of the question, the easiest call, if you know the law, the mandatory death penalty statute. It's on its face a violation of the Eighth Amendment. I figure a way to string this out for 4 or 5 sentences. The analysis, I think, is clear. It's a simple question. It deserves a simple answer. Finally, we focus on the conduct of Jane in shooting Al. And here, once again, I lead with the facts. She fired a shot and killed Al, who was running away after Doug shot Jane. She used a deadly weapon, so malice is established again. And then I recite the rules about what authority a police officer has to use deadly force to apprehend a fleeing felon. And the bottom line is, Jane doesn't appear to have acted within the law. She almost certainly did not premeditate. I don't think this is a first-degree homicide. But had Jane not been killed, I think probably she would be convicted of common law murder. So that wraps up an analysis of another one of these short fact patterns that gives rise to its own set of challenges.